I'd like to get started, and it's 10 o'clock. Again, I'd like to just reiterate some of the housekeeping. If anyone wants to ask, or during the call, you need to mute your phones so there's no background noise. But if you have a question during the presentation, please unmute your phone and you can ask the question and I'll be able to respond. Also, we've gotten CLE credit for this CLE, and please send an email to Katriska with your state bar number, and she will file for CLE credit for you. If there's folks that who want CEU credit, please send an email to Katriska, and she will send you the course number so you can apply on your own for CEU credit. I'm really excited about this presentation on the guardianship reforms of 2015. This is the first time that we are giving this presentation, and these reforms are significant and it's important for people with disabilities throughout the state, and it's pretty critical for us to be familiar with these changes. I'd like to thank Belinda Carlton with the DD Council who helped me put together this PowerPoint. I'd like to talk a little bit about the road to guardianship reform in Texas, just briefly, and give you some background regarding this effort to reform the estate code. First of all, it started back in 2013, and there was a lot of advocates, family members, and people that were very concerned about guardianships in Texas. We had heard numerous stories and accounts of people feeling as though courts were just routinely granting full guardianship and basically rubber stamping guardianships that took people's rights away. And so in the summer of 2013, a group of advocates started to meet with Adaptive Texas. Bob Kafka set up these meetings, and this group consisted of representatives of various disability and senior groups. And we had the Adaptive Texas, architects, I hear some background noise. Whoever has it, could they mute their phone, please? Someone has their speaker phone on. Please mute it. Thank you. Back in the summer of 2013, all these groups started meeting, and we literally spent almost 2 years negotiating with the group on agreements on how the guardianship system could be reformed in Texas. And as a result of a pretty contentious and often heated debates about what should be covered in the guardianship reforms, the GRSDM group came up with 8 proposals that were designed to reform the guardianship system in Texas. And it's pretty interesting that all the reforms were adopted by the legislature except for one, which was intended to change the term ward in the estate code to person under guardianship, and there was no support for, or very little support for that, and so that provision died. But all the other proposals that the GRSDM group came up with were actually enacted into the legislative reforms. The other thing that happened is sort of the timing of the guardianship reforms was sort of timely, because the state of Texas created a WINGS group, which was the Texas Working Interdisciplinary Network of Guardianship Stakeholders. And there were a group of states in the country where they created these WINGS groups in order to look at reforming guardianship. And in Texas, we had a WINGS group, And the proposals that were adopted by GRSDM were submitted to WINGS, and that the WINGS adopted almost all of the proposals. And the Office of Court Administration in Texas took a leadership role in promoting the adoption of these guardianship reforms. So what I'd like to do now is to go over the reforms enacted by the legislature. First of all, the 84th legislature passed 4 bills protecting the rights of persons with disabilities in the guardianship system. We had HB 39, which dealt with alternatives to guardianship. There was Senate Bill 1881, which was supported decision-making bill. Senate Bill 1882, which was a Bill of Rights for people that were under guardianship, as well as HB 1438, which dealt with court-initiated guardianships. And I'll explain a little bit more about what court-initiated guardianships in a few minutes. Throughout the PowerPoint, I've made references to the estate code and not the bill provision, so that if you, in the future, all these provisions are going to be codified. So if you need to find these laws, you would look at the provisions in the estate code. The effective date of the guardianship reforms is coming upon us very quickly, and they go into effect September 1st, 2015. So it's really important for us to start educating lawyers and judges and family members and people with disabilities about these reforms as soon as possible. The guardianship reforms that were enacted constituted significant changes in the way that we've dealt with guardianships in Texas. For the first time, the Texas Legislature mandated that probate courts had to consider alternatives to guardianships and supports and services before a guardianship is created. This is very significant. Secondly, Texas became the first state in the nation to create supported decision-making, or recognizing supported decision-making in a statute as an alternative to guardianship. And I'll be talking a little bit more about supported decision-making. But again, this is very significant because we are the first state in the union to do this. Alternatives to guardianship. In the estate code, the legislature specifically identified alternatives to guardianship that could be used to prevent the need for or to avoid the necessity of having a guardianship. And the reason why this was put in code is that a lot of these alternatives are already existing or are used, but it's important to codify the alternatives so that the attorneys representing people in guardianship proceedings, the lawyers representing people who are seeking guardianship, family members, people with disabilities, advocates, now know where to find the list of approved alternatives to guardianship. And I'm just going to go over them briefly. The first one is a medical power of attorney, which allows a person to be able to have another designated person to make medical decisions. I think someone is typing. Please put your phone on mute. The second one is a durable power of attorney, and this is a power of attorney where you can designate a person to make financial decisions, assist in making all sorts of decisions regarding applications for services and other areas that allows a third party to make those decisions. The Declaration for Mental Health Treatment is an advanced directive, and this was enacted in the late 90s. It allows people with who have mental health issues to be able to execute an advanced directive prior to being admitted into a psychiatric hospital to designate what type of treatment they prefer regarding medication, whether or not they want to be subjected to ECT, whatever. But it's a tool that's available. As most people know, another alternative is the representative payee. Most of the people that we represent do not have large estates. They may be receiving SSI benefits, and that a representative payee could be used to help manage the person's SSI benefits and avoid the need of getting a guardian of the estate. Joint bank accounts is another way of assisting a person to help manage their finances and to avoid the need of getting a guardianship. We also have management trusts for people that have large estates where a bank or some other holding company can manage their estates. The special needs trust is pretty unique to people with disabilities, and it allows a person, and is extremely important, to allow a person who may inherit money or have proceeds from a damage action to put their resources in a special needs trust. And this allows the person to continue to receive SSI benefits as well as Medicaid benefits. The ARC of Texas has a special needs trust that they manage, so if a person's interested in pursuing a special needs trust and doesn't want to hire a lawyer to create one, they could look at what's available through the ARC of Texas. A designation of guardianship before the need arises allows a person who has the capacity to designate a person that, if they become incapacitated, would allow that person to make decisions or to be named as their guardian. The ninth one is alternative forms of decision-making based on person-centered planning. And this is pretty important because in the disability community, a lot of people go through person-centered planning where you have a circle of support or other people, where a person with disabilities has people that are valued in their life, maybe service providers, family members, friends, that meet with them, and they develop a plan that will help make decisions about where they live, work, treatment decisions, what have you. And so a person-centered plan is considered an approved alternative to guardianship. The last alternative is supported decision-making, which we'll talk about in a few minutes. Supports and services is now defined in the estate code, and I think this is pretty critical. And it's important. I think that the courts and the probate attorneys have lagged behind the advancements and developments that we in the disability community have achieved regarding integrating people with disabilities in the community and providing supports and services that will allow people to live in the community and maximize their independence and avoid the need of institutionalizing people and to have guardians. And so, and I'd just like to deviate for a second to give you an example of why supports and services are important, and then I'll talk about the definition. Disability Rights Texas had a case that was litigated by Kayla, Lisa, and Beth that dealt with a young man that was in a state-supported living center, and that his grandmother was his guardian, and she passed away about 7 years before we got involved in the case. And during that period of time, after his grandmother passed away, he was engaged with his treatment team, and he made medical decisions, he made treatment decisions, he made all the decisions that he needed to make. And the treatment team was recommending that he be moved into the community. And then they realized that even though he went out, he saw different HCS homes, and he decided that he wanted to reside in a particular HCS home, he did not have the legal capacity to consent to moving into an HCS placement. So the State Supported Living Center referred him to Disability Rights Texas. We ended up filing a petition with the probate court to restore his capacity. And in that case, we argued that since that he had been making treatment decisions and medical decisions and financial decisions for years while he was in the State Supported Living Center, that he should, and that he was going to be continued. He had the support of his treatment team. When he moved into an HCS home, he would have those treatment team supports, and that he should be able to make those decisions on his own with supports and services. And what happened was that the probate court denied the restoration, and Disability Rights appealed that case, and the appellate court basically held that disregarded the whole argument regarding supports and services and our client's past history and demonstrating that he was capable of making these decisions on his own. The court was concerned about what would happen if he discontinued getting services in the community. So the appellate court upheld the denial of the restoration of our client's capacity. The case is that we've requested an appeal to the Texas Supreme Court, And the key element in this case is the whole notion of supports and services, where we've argued that before a court can enter a guardianship, they have to consider whether or not a person has access to supports and services that either will eliminate the need for a guardianship or limit the powers and responsibilities that are awarded to a guardian. And so in light of the litigation that we did in this Toner case, there was an effort to try to define supports and services and incorporate that requirement into the estate code. And in the estate code now, we have a definition of supports and services, and it means both formal and informal resources and services that enable an individual, one, to meet their individual needs for food, clothing, and shelter, to care for the individual's physical or mental health, manage their individual's financial affairs, and to make personal decisions regarding residence, voting, operating a motor vehicle, and marriage. And so now we have a clear definition of what is meant by supports and services, and I think it's going to be really incumbent upon advocates, both in the disability community as well as advocates within Disability Rights Texas, to really educate family members who are seeking guardianships, to educate lawyers and other folks about what are supports and services, because if we are knowledgeable about the supports and services that are available through the various waiver programs, and that unfortunately a lot of the people who've been making decisions about whether or not individuals need to be under a guardianship are not aware of the advances that we've made in supports and services. So it's critical for us to be able to provide that information to the courts. The one nice thing that the legislature did is to mandate training for lawyers on alternatives to guardianship. Currently, the law requires that ad litem or attorneys that are involved in guardianship cases complete a course of study approved by the court on guardianship. And what the legislature did, which I thought was interesting, was that they expanded this requirement not only to court-appointed attorneys representing people in guardianship proceedings, but also the attorneys representing the applicants in guardianship. So these are the people that family members approach and decide on what types of guardianship should be sought. And so what this training requirement has added is that all lawyers that are involved in guardianship proceedings now must be certified, but as part of the certification, there has to be 1 hour of training devoted to alternatives to guardianship and supports and services available to proposed awards. And I think this is critical. This is the beginning of us trying to educate lawyers about the advances that have been made on behalf of people with disabilities. The next provision in the code and with alternatives is for attorney ad litems. And what it requires is that the attorney ad litem, when they're appointed, in every case in a guardianship, the court appoints an attorney ad litem to represent the proposed ward in the guardianship proceedings. And now, one of the duties of an attorney ad litem is that they have to discuss with the ward whether alternatives to guardianship would meet the needs of the proposed ward and avoid the need for an appointment of a guardianship. And secondly, before the guardianship hearing, the attorney has to sit down with the client and discuss with them the attorney's position about whether a guardianship is necessary, and if a guardianship is necessary, the specific powers and duties of the guardian that should be limited if the proposed ward receives supports and services. So what it does is it places a focus first up front where the lawyer has to talk to the client about alternatives. So if there's an alternative to getting a guardianship, for example, if the whole purpose is someone seeking a guardianship to manage someone's SSI benefits, they could come in and say, hey, let's do a representative payee to avoid the need for a guardianship. The other thing that's important is regarding trying to limit, in order to promote, and someone just turned on the phone. Please put it on mute, please.
Sorry.
In order to promote the least restrictive forms of guardianship, they have to, the advocates, the lawyers representing the wards, have to be able to argue to limit the powers or duties of a guardian. And the way to do that is to say if the ward receives certain supports and services, the guardian doesn't need to have these additional powers. And so it's really critical for the lawyers to be trained and to know about these alternatives, as well as being required under statute to advise their clients about these options. Next slide. The duties to investigate alternatives for guardian ad litems. In a lot of cases, especially cases where disability rights have gotten involved in representing people in restoration of capacity proceedings, the courts often appoint guardian ad litems. And the guardian ad litem has a duty, and in some cases the guardian ad litem is an attorney, in other cases it could be a social worker, but the legislature specifically mandated that the guardian ad litem had to investigate whether the guardianship is necessary and evaluate alternatives to guardianship and supports and services that would avoid the need for a guardianship. So the duty is not only, this duty to investigate alternatives is not only on the attorney ad litem, but also on the guardian ad litem. And the one difference between the attorney ad litem and the guardian ad litem, when an attorney meets with their client and gives them and advises them about alternatives or supports and services, that's confidential and it's protected by the attorney-client privilege. For the guardian ad litem, since they are there allegedly looking out for the best interest of the proposed ward, and they are not the attorney for the proposed ward, that they are the information that they gathered is subject to examination by the probate court. And so if there's a guardian ad litem, the guardian ad litem could submit an investigation report to the court, or at the guardianship hearing, they could testify and give their opinion to the court about whether or not whether or not there's alternatives to guardianship, or whether or not there's supports and services that would avoid the need for a guardianship. The application for guardianship, and I think this is again another very positive move to emphasize that we need to take seriously the alternatives to guardianship. Typically, when you see a guardianship application, the person who files a guardianship just goes in, the lawyer drafts a request for guardianship, and normally just asks for a full guardianship. And what this requires now is that when an application for guardianship is filed, the applicant must swear under oath, one, whether alternatives to guardianship and available supports or services are available to avoid the guardianship have been considered. So there's an affirmative duty on the part of the person seeking the guardianship. Did they ever think about alternatives? Did they ever think about supports and services? And so they have to state whether or not they considered it. And so when a lawyer is advising a client about whether or not they need to get a guardianship, the lawyer has to advise them about alternatives, and they got to advise them about supports and services. They also have to state whether or not alternatives to guardianship or supports and services are feasible and would avoid the need for a guardianship. And finally, they have to state in the application whether or not the proposed ward's right to vote, operate a motor vehicle, and make personal decisions about residents should be terminated. And throughout the guardianship reforms, there's a lot of references regarding making decisions about residents. For people with disabilities, this is a critical decision about where they live. And often people with disabilities, when they're under a guardianship, are stripped of the right of making decisions about their residents, even though they may have a capacity to decide where they want to live. For example, if someone's in a state-supported living center and the treatment that they that they can move into the community in an HCS home or in the community, if someone becomes their guardian, the proposed ward has expressed a desire to move into the community, and the person may have the capacity to decide that they have the right to make, or the capacity to make that decision about where they want to reside. But if the court doesn't address the issue about their personal who has the authority to make their decision about residents, the guardian can make it and say, no, you got to stay in the state supported living center. So it's important for the courts to focus on whether or not individuals have the right to make a decision about where they're going to live. And again, it's incumbent upon the lawyers representing people to advise them about that. And you know, the one thing is we talk about advising people about their rights. It's also incumbent upon these attorneys representing the proposed wards to fight for these rights. And at the guardianship hearings, contest that, you know, these alternatives need to be followed. The person has the supports and services, they don't need a guardianship, or it's a limited guardianship, or that if there's a guardianship, the person should retain the right to vote, operate a motor vehicle, and decide where they're going to live. The medical exam. In every guardianship proceeding, before the court can grant a guardianship, there has to be a physician, and in some cases it involves a person with an intellectual disability. It could be a psychologist, in order to file a letter or certificate with the court stating whether or not a person needs a guardianship. It focuses on whether or not they're incapacitated. But now with the guardianship reforms, there's a mandate that when a physician or psychologist does one of these assessments, they have to state whether the proposed ward there's a likelihood that there's going to be improvement in their physical condition or mental functioning if it's feasible or possible. And if so, state when the proposed ward should be reevaluated to determine whether or not the guardianship continues to be necessary. And the interesting thing about this is you may have people, for example, someone with a traumatic brain injury that may have, when the guardianship is established, may be comatose or may be at a point where they are unable to make decisions on their own. But if they're in the course of getting treatment and healing, their doctors may say that within 6 months to a year, that their condition will improve and that their traumatic brain injury will be improved, and that they should be reevaluated to see whether or not they continue to need a guardianship. The doctors and also need to state whether or not the ward is able to administer activities with supports and services. So it's interesting, and I think one of the things that we're going to need to do. Will you please put your phone on mute, please? That the doctors are also going to need to be aware of supports and services, and to be aware of what's available in the community that allow people to live independently. Finally, in the medical exam, they have to state whether a guardianship is necessary, and if so, what specific powers or duties of the guardianship should be limited if the proposed ward receives supports and services. And so here's another opportunity for the doctors to be able to go in and make those determinations. The one thing, again, falling back on the lawyers representing the proposed ward, is that as part of representing a client in one of these proceedings, you should talk to the doctors, and if they didn't include whether or not there's alternatives or supports or service that could be utilized to limit the powers of the guardian or the need for the guardianship, they need to talk to the doctor. And in some cases, you may have to even educate the doctor about the supports and services, and it may mean that we need to start connecting the dots. If a person is in an HCS home, that we may need to have to provide information from the HCS providers or any other providers that could be given to the doctor to say, look, this person with these supports can make these types of decisions in order to help them modify their recommendations. And finally, if the physical exam or mental exam finds that the ward's physical condition or mental functioning is likely to improve in less than a year, the order appointing a guardian must include the date by which the guardian must submit to the court an updated medical examination. Findings required for guardianship orders. And before appointing a guardian, there's certain evidence that's required. And the probate court, as a result of a trial, as a result of evidence, and it could be either a trial to the court or it could be a jury trial, where the court has to make a finding by clear and convincing evidence that alternatives to guardianship and supports and services have been considered and determined not to be feasible. This is only when the court determines that a person needs a full guardianship. And if the court grants a limited guardianship, then the court must specifically state whether or not the proposed ward lacks the capacity, with or without supports and services, to make decisions about their residents, as well as all the other powers. If the court could limit the guardianship, if people have access to supports and services, then they could do that with a finding of clear and convincing evidence. The order for full guardianship must specifically state that whether or not the ward has the capacity to make personal decisions about residents. And so if a person has a full guardianship, the order specifically has to state that they don't have the capacity to make those decisions. The interesting thing is what happens if they don't? That finding is not, or that order is not made entered in the guardianship order. I would argue after September 1st, if they fail to put in an order, you can argue that the ward retains that right because it wasn't in the court order. Orders appointing limited guardianship and supports and services. Again, the order must specify the specific rights and powers retained by the ward, with or without supports and services, and again, whether or not the ward retains the right to make personal decisions. So the orders that are going to be entered are going to be more individualized after we've moved towards consideration of supports and services, and that the courts would specifically address whether or not a person has the capacity to make certain decisions based on the availability of supports and services. Choice of guardian and the ward's preference must be considered. Before the court appoints a guardianship, the court should make reasonable efforts to consider the ward's preference of the person to be appointed guardian, regardless of whether or not the person designated by the ward was before the need arises. And this is important. Often what happens is that when a guardianship is done, the applicant files, they get appointed to be the guardian. And the ward has no say or very little say into who should be appointed. And so now it's required that the court has to make a reasonable effort to determine who they want, who the ward wants to be their guardian. And again, this falls back on the attorney ad litem. There's a duty now on the attorney ad litem to talk to the wards about who would they like, if they need a guardian, who do they want to be their guardian. And the one thing that I've noticed in a lot of the work that we do here at Disability Rights Texas, we don't often get involved when someone is seeking a guardianship. It's normally after the guardianship, and family members will contact us or the ward will contact us, and they have problems with the guardian. And it reminds me of family law, is that you have ongoing battles between the family members over control of the ward, either wanting to make decision over them or having control over their estate. And there are ongoing battles. So it gets very contentious. And so I think that it's very important for the court as well as the ad litems to consider the desires of the ward in seeking the appointment of the guardian. This is a very important change, and it seems as though in the guardianship reforms, as well as the Bill of Rights I'll be talking about in a couple minutes, there are gems in the law, and this is a gem. Right now, under current law, once a person is under a guardianship, the guardian can decide where they live. If a person's living in their own home, or if they're living in a community setting, if the guardian decides they need to be placed in a nursing home or an institution, they get to do it. And what's happened with the guardianship reforms is that even though a guardian may have the right to decide where a ward lives, they can only place a ward in a more restrictive setting if the guardian provides notice to the court, the ward, and any person who's requested notice. And this is after the court orders the placement. The court has to order the placement after a hearing if the ward or another person objects to the proposed placement before the 8th business day after the receipt of the notice, or the 7th business day after the court's receipt of notice, as the court does not schedule a hearing on its own motion before that date. So what's required is that when guardians are wanting to move people into more restrictive settings, they have to get court approval, and the ward needs to get notice, and any person who's requested notice. So if there's a family member, if there's an advocate, if there's someone that has been working with a ward or supporting them, they could give notice to the guardian and state, if you're going to move the ward into a more restrictive setting, I want notice. And then that person would have the option of objecting to the proposed placement and having a hearing, and the court would have to make that decision. The capacity, a guardianship will be closed when the court finds that the ward has sufficient capacity with supports and services to care for himself and to manage his or her own property. So as a basis for a restoration, if a person is under a guardianship, be a full guardianship or even a limited guardianship, if a person has sufficient capacity with supports and services, they can go back in and ask the court to close the guardianship and restore their rights. And the next slide deals with steps to end or limit guardianship. In the code, it's referred to restoration of capacity, and this allows a ward or any interested person to petition the court for the full or partial restoration of the rights, including the right to decide the residence if or he or she has capacity with or without supports and services. And so this allows people that are currently under guardianship, if they wanted to have their capacity restored, they can file a petition with the probate court in order to have their capacity restored, with or without support. So a person may come in and say, I don't need support, I have the capacity, I can make these decisions. Another person can come in and say, no, I have a supported decision-making agreement, I have a neighbor who helps me pay my utility bills and helps me grocery shop, I'm in an HCS home, and these people, the treatment team is helping me make decisions. So you can go into court and present a case like that and ask that the person's rights be restored. And the court shall consider whether or not the guardianship is needed and whether or not the specific powers and duties of a guardian should be limited if the ward receives supports and services. And if the court grants this, the court has to, or in the court order, they must specifically state any supports and services needed for the restoration or the modification of the guardianship. And when modifying a guardianship, the court must state whether or not the ward retains the right to make personal decisions about where they're going to live. Supported decision making. I want to talk a little bit, provide some background on supported decision making. This is revolutionary. Supported decision-making is a result of a movement that occurred in Europe and in Canada, where people were concerned about people with disabilities being placed under guardianship, where they're being stripped of all their rights and the power to make decisions in their lives. And so in Europe and in Canada, the governments have recognized supported decision-making, and this allows a person with a disability to select a supporter to assist them in making decisions about their lives. And I think that, and there's been a lot of discussion about the Jenny Hatch case. A couple, I think last year we did a training on guardianship, and we sent out some information about Jenny Hatch, and she was a young lady who, out of Virginia, who wanted to live in the community. She had friends that she could live with. Her parents did not approve of this move. Her parents sought a full guardianship they got it and placed her in a group home, or they wanted to place her in a group home. And she contested it, and the court, because she had supports and services or supporters who would assist her in making decisions in her life, the court approved or denied the guardianship and allowed Jenny with her supporters to those decisions. Even though the Jenny Hatch case was not didn't involve a per se supported decision-making agreement. Someone has their phone on. Please put it on mute. But again, it started in the United States, this whole movement towards supported decision-making. Quality Trust in Virginia has some excellent materials on supported decision-making, and if you're interested, you can go to their website. But again, even though the push for supported decision-making originated on the East Coast, Texas was the first state to recognize supported decision-making as a substitute for guardianship. And when GRSDM started looking at supported decision-making, we found out that in, I think, 2009, the Texas Legislature created a pilot for supported decision-making, which was just remarkable that Texas was in the forefront of promoting supported decision-making, even though no one in the rest of the country knew about it. But anyways, as a result of this pilot, the ARC of San Angelo received funding to create a supported decision-making project. And they created a project where they were able to get supporters or volunteers who are matched with people with disabilities to assist them in making decisions. So Texas has really taken the lead on supported decision-making, and the project in San Angelo was a success. And so what we were trying to do, or what the legislature did with the enactment of the supported decision-making agreement, was to go to the next step in recognizing the value of supported decision-making. And the final thing that I want to say is the time has come for supported decision-making. And, with the 25th anniversary of the Americans with Disabilities Act, we have the first generation of young people who've been raised with equal rights, raised with the notion that they should be treated equally, they have a right to be integrated in the community, they have the right to make decisions on their own. And so supported decision-making is really consistent with the movement within the disability community towards integration and independence. And the one thing that I think is a key component to supported decision-making is that people just don't wake up one day after they've been treated, where their parents or providers have been making decisions for them all their lives, to say all of a sudden with a magic wand that they can make their own decisions. And so I think that the next move that we need to advocate for is the schools, and that at an early age, kids with disabilities, like non-disabled kids, should be allowed to make decisions, even though schools probably do not want to hear what the kids want to say or decide. I think it's important that the schools need to give options to kids about making decisions. We need to start training kids how to make decisions, and especially as kids get older, over the age of 16, with the transition plans. As advocates, and I know that there's a lot of folks on our education team on this call, is that you need to start advocating in your transition planning that the schools teach youth how to make decisions and to start developing curriculum on decision-making. What is supported decision-making? The definition that was incorporated in the new guardianship reform was the definition that was in the pilot back in 2009. And supported decision-making is designed as a process of supporting and accommodating an adult with a disability to enable the adult to make life decisions, including decisions related to where the adult wants to live, the services, supports, medical care that the adult wants to receive, whom the adult wants to live with, and where the adult wants to work, without impeding the self-determination of the adult. What is the purpose of supported decision-making? And again, the statute defines the purpose. It's to enable the person with a disability to make these decisions without impeding their self-determination. And so the whole focus is on independence. Who can enter a supported decision-making agreement under Texas law? Any individual over 18 who has a physical or mental impairment that substantially limits one or more major life activity. So basically the definition of a person with disability from Section 504 was incorporated into the definition for who's eligible for getting a supported decision-making agreement. The one interesting thing is that the level of capacity of a person, that the person who wants to enter a supported decision-making must have the level of capacity in order to enter a supported decision-making agreement. That the statute does not define that level of capacity. But a person must have sufficient capacity to agree to the supporter assisting him in making particular decisions. When some of the earlier proposals regarding supported decision-making, there was an attempt to put a definition of capacity which was more like, a little bit lower than the capacity to enter into a contract and to do a power of attorney. And a lot of the probate judges were opposed to this definition. And their contention was, well, if a person could has that type of capacity, they should be able to do a power of attorney. And I think that the judges didn't understand what a supported decision-making agreement was, but intentionally to avoid the objections of the judges and concerns about capacity, that section was not included in the legislation. The other thing is that even within the GRSDM group, we had parents with kids with significant disabilities who were and are skeptical of getting guardianships because some of them are fearful that as a result of getting a guardianship, they expose themselves to the probate court possibly scrutinizing their ability to make decisions for their kids, their adult children, and then possibly referring to adult protective services, and they're losing the power to make these decisions. And so a lot of the parents that were in the work group wanted to be able to have supported decision-making agreements with their youth, adult youth or children who have significant disabilities. And the bottom line is that our position was, even though they were accusing us of selling them out and selling their kids out by having a watered-down version of supported decision-making, the bottom line was that the law required, and supported decision-making requires, that the person with a disability has to know what they're entering into. They have to agree to having a person help them make particular decisions. And it isn't just a rubber stamp where a person puts a mark on a piece of paper and allows someone else to make decisions on their behalf. Who can be the supporter? And the law does not place any restrictions on who can be the supporter. Essentially, any adult can be a supporter. The importance is that the supporter has to be the person who, with a disability, who needs support, has to decide on someone they trust. And that typically the supporter can be a family member, a relative, a friend, a former teacher, a former coach, somebody that they have a relationship with and that they have that they can trust. And that it isn't something where we would just go out and get someone out of the blue and say, well, you're the supporter and you're going to serve this role. Is that it's all based on relationships, and that the person with a disability needs to make that decision, and they have to have a relationship with someone that they trust. The supporter cannot be superimposed and cannot be, and that the a service provider, a parent, a lawyer cannot tell someone, this is the person that has to be your supporter. It's the choice of the person with a disability. And it all goes back to self-determination, and we don't want to do anything that would impede the person's right to make decisions on their own behalf. The supported decision-making agreement is voluntary. The adult with a disability decides that they need support with decisions, and that they're the ones that understand that this is something they may need. and that the person with a disability and the supporter must enter the agreement voluntarily. They cannot be coerced. They cannot be threatened. They can't be told, you better enter this supported decision-making agreement or I'm going to get a guardianship. It's just like a power of attorney. Powers of attorney are done voluntarily. That a person decides that they want someone to have a power of attorney, it's a choice. The other thing about supported decision-making, it's informal. It does, even though the legislature approves supported decision-making agreements, even though the statute has a sample form for supported decision-making agreement, it does not require going to court to approve the supported decision-making agreement. In some jurisdictions, especially in Canada, supported decision-making agreements have to be approved by the courts. The courts have monitors that monitor the supported decision-making agreement. In Texas, we do not have that. How is a supported decision-making agreement different than a power of attorney? And it is very distinct from a power of attorney because it does not allow a person to make decisions for a person with a disability. The supporter does not make decisions. In a power of attorney, a person executes a power of attorney. That person makes those decisions. You're delegating that power to a third, to someone else. A supported decision-making agreement does not do that. The person with a disability retains the right to make all decisions in their life. The supporter there is to assist them. So what can this supporter do? Under the Texas statute, they can do several things. First of all, they can assist the adult with a disability in understanding options, responsibilities, and consequences of life decisions, so that the supporter is there. And when a person with a disability has to decide whether or not they want to move out of a HCS home into their own apartment, if they decide they want to move out of an institution into the community, whether or not there's a concern about whether or not they need to have a certain medical procedure, or get a job, or apply for benefits, the supporter would be there, just like many of us who have young adult children, that our kids come to us and we give them advice and talk to them about their options, but it's not our choice. Same here with the person with a disability in a supported decision-making agreement. A critical role is for helping the person with a disability understand the options. And that's why I think it's critical in the supported decision-making agreement that the person with a disability trust the supporter. The second thing that they can do is assist the adult with a disability in accessing, collecting, obtaining medical, psychological, financial, educational, and treatment records. And so the person, the supported decision-making agreement in and of itself is not an authorization to access confidential information. We have HIPAA, we have FERPA, we have all these confidentiality laws. This is not a supported decision-making agreement does not trump those. That a person with the person with a disability needs to execute an authorization form or a consent form to allow the person, the supporter, to assist them in getting records. Sometimes it takes an act of Congress or a lawyer to help a person get access to their school records, their mental health records, what have you. And so that sometimes people with disabilities have difficulty accessing and obtaining those records. And that's a role that a supporter can do to assist them in getting those records. Third thing is that once the records are obtained, the supporter can assist the person with a disability in understanding the information that's contained in the records. So the supporter should, if they get records, should not just pocket the information and not tell the person with a disability. They need to sit down and go over that information with the person. And the purpose of getting access to information isn't just a matter of opening up a case and compiling all the records that a person has into one file. The purpose is getting records to assist a person in making decisions. And so there may be a time, for example, if we have someone who's 18 years old and they have a supported decision-making agreement and they're still in school, the supporter may assist the person in getting copies of assessments at school and art documents so they can assist the person in making decisions in ARD meetings. The third thing is as I said, or the last thing is to assist the adult with a disability in communicating his or her decision to appropriate persons. So this is something where, especially with people with disabilities, they may have difficulty communicating, and the supporter can assist the person in communicating their decisions to service providers and other people. When does a supported decision-making agreement end? It can be terminated by the adult with a disability or the supporter at any time. It also could be terminated by the terms of the agreement. The supported decision-making agreement could say this agreement will only last for a year. It could also be terminated if the Texas Department of Family and Protective Services finds that an adult with a disability has been abused, neglected, or exploited by the supporter. So if there's a confirmed case that the supporter is exploiting or abusing the person with a disability, the supported decision-making agreement ends. Finally, if the supporter is finally criminally liable for the abuse, neglect, or exploitation of the adult with a disability, the agreement ends. Confidential information. The supporter is only authorized to assist the person in accessing, collecting, and obtaining information. This includes protected health information under HIPAA and HB 300, as well as education records under FERPA. A supporter is required to keep this information privileged and confidential, and is not subject to unauthorized access or use or disclosure. So if a supporter gets a client's or a person with disabilities medical records or mental health records, that doesn't give them the right to turn those records over to a provider or anyone else. It's up to the person with a disability to make that decision and consent to the release of those records. And the supported decision-making agreement, however, does not prevent an adult with a disability from seeking personal information on his own without the assistance of a supporter. So even though a person may have a supported decision-making agreement, they can get access to their own records as they currently are under the law. The requirements for a supported decision-making agreement. First of all, the adult with a disability and the supporter must sign the agreement voluntarily in the presence of two witnesses over the age of 14 or notary public. So that there has to be witnesses to the supported decision-making agreement. There are also, under in the statute, there's a sample agreement. And so that just like in the estate code, there's a sample power of attorney, the legislature has approved a sample supported decision-making agreement that can be utilized by Texans from now on. The supported decision-making agreement can be in any form as long as it substantially complies with the form or the elements in the form that's in the estate code. And the DD Council has developed a simplified supported decision-making form that's on their website. And the one thing is that people, in order to make the supported decision-making agreements accessible to people with disabilities, the DD Council has attempted to draft a supported decision-making agreement and taking out the legalese and making it understandable to most people. What are the liabilities and risks of supported decision-making? A person may rely upon, and this means a doctor, a bank, a school, a provider can rely upon the original or a copy of a supported decision-making agreement. And a person is not subject to criminal or civil liability or professional misconduct for an act or omission done in good faith and in reliance upon a supported decision-making agreement. What if someone suspects? Let me just see. Hold on. If someone suspects abuse or neglect, if a person who receives the supported decision-making agreement or is aware of the supported decision-making agreement has cause to believe that an adult with a disability is being abused, neglected, or exploited by the supporter, they have a duty to report the abuse, neglect, or exploitation to the Texas Department of Family and Protective Services. Does the supported decision-making agreement guarantee informed consent? Nope. And this is something. Someone turn their phone on. Please mute it. Just because a person has a supported decision-making agreement does not mean that the person that they have the capacity to make a particular decision. The person with a disability, with the support of their supporter, can demonstrate that they have the capacity. The supporter can assist the person in understanding and communicating what is needed to provide informed consent. And they can assist them in rebutting these paternalistic biases against people with disability, that they assume that just because you have a disability, you lack the capacity. However, if a person goes to a doctor and they have to have major surgery, and there's a question, and the doctor's seeking informed consent from the person with a disability, the decision to accept the informed consent provided by the doctor is made by the doctor, and not by and it isn't trumped by the supported decision making in and of itself. The Bill of Rights. When the GRSDM started looking at the law or at the guardianship reform, there was discussion about a need for the Bill of Rights. And back in 2013, and I think to this date, there's only one other state that has a Bill of Rights for people that are under guardianship, and that's Minnesota. And the Texas Bill of Rights was modeled after what was done in Minnesota, but also expanded it. And the reason why the Bill of Rights was created was to compile in one statute all the rights for people that are under a guardianship. And and so it makes it easier for people under a guardianship, their guardianship, and attorneys who are representing people in guardianship proceedings to be aware of what the rights of the wards are. So it's easy to find. It's in one section. And so the Bill of Rights that was adopted or enacted by the legislature basically covers the state and federal rights of persons under guardianship are in the estate code, but they're essentially the rights that appear elsewhere. The cornerstone for the Bill of Rights is that a person under a guardianship has all the rights, benefits, and responsibilities and privileges granted by the Constitution and the law of Texas and the U.S., except were specifically limited by court-ordered guardianships or were otherwise lawfully restricted. So basically, people under a guardianship have all their rights that everyone else has, unless they were limited by a guardianship. And in the Texas law, we have 24 rights. And so unless the following, and I'm going to go through all the rights, but unless the rights are, any of these 24 rights are limited by a court, the award has them. And the interesting thing about the whole process of behind the Bill of Rights, even though we called these the Bill of Rights, the leadership at the legislature had concerns about various versions of this law. The first version was it said a ward has the right to the following, and someone said no, that's not good enough. We don't want to. We're afraid it's going to. It's too strong of a language, and so then it was changed to a ward is entitled, and there was objections to having that. Again, thinking it's creating too many rights and it's maybe too litigious. Who knows? But finally, the compromise language was a ward is authorized to the following. So we have a Bill of Rights, and people are authorized to do the following. The first one is to have a copy of the guardianship order and letters of guardianship and contact information for the court. It is unbelievable that we at Disability Rights Texas frequently get calls from people complaining about their guardianship, complaining about their wanting to restore their capacity, and we ask them if they have a copy of their guardianship I've never found, or we've never had one person tell us they had a copy of the guardianship order or the letters of guardianship. And in a lot of cases, people don't even know how to contact the probate court. And so now they have a right to have that information in the Bill of Rights. Also, they have a right. They have a right to a guardianship that encourages the development or maintenance of maximum self-reliance and independence in the ward, with eventual goal, if possible, self-sufficiency. And I think this is extremely important, because I think normally we look at guardianship, even though we have to do renewals every year, they're static. Once you're under a guardianship, it's almost impossible to get rid of it unless you fight in court to have it removed. This codifies or creates a right to realize that guardianship and the need for these types of limitations on people's rights are fluid and should change over time as a person gains the capacity to make their own decisions and to live independently. The third right is to be treated with respect and dignity, with recognition of the word's individuality. Also, right number 4 incorporates the Olmstead mandate under Title II of the ADA that says that a person under a guardianship has the right to reside and receive supports and services in the most integrated setting, including home-based and other community-based settings required under Title II of the ADA. A lot of times people are getting guardianships to prevent people from moving out of state-supported living centers into the community. Hopefully this Bill of Rights will show them that they can't do that. Second, the fifth right is consideration of the ward's current and previously stated preferences, desires, medical and psychiatric treatment preferences, religious beliefs, and living arrangements. And so the law, in Texas, it isn't clear what a guardian needs to rely upon when making decisions regarding treatment for people. At least now in the code, that the guardian has to give consideration to what the ward wants. And I think this is an important step. Also, the sixth right is to financial self-determination for all public benefits after essential living expenses and health needs are met, and to have access to a monthly personal allowance. So this means that everybody, if you're getting SSI and it's paying for your placement, you're entitled to a personal allowance. I can just tell you that we at Disability Rights litigated a case for many years where a person had a large estate and his guardian would not allow him to have money and to buy a Dr. Pepper or to go out to dinner once a week. And we actually had to litigate a case to establish our client's right to get access to that. Right number 7, right to receive timely and appropriate health care and treatment. 8, the right to exercise full control of all aspects of life not specifically granted to a guardian by the court. This goes back to the right to look at the orders. A person has a right, if a right isn't taken away by a guardian in a guardianship order, the person under a guardianship retains that right. The number 9, to control the ward's personal environment based on the ward's preferences. So if they want to decorate their home, they want to decorate their room, a person has a right to do that. Number 10, they have a right to complain or raise concerns regarding the guardian or the guardianship to the court, including living arrangements, retaliation by the guardian, any conflicts of interest between the guardian and service providers, and more importantly, a violation of any of the Bill of Rights. So if a person has a complaint, they can bring it to the attention of the probate court. Number 11, and this is a very important right. Normally when we did renewals of guardianship every year, it's all done by paper. The guardian files their annual report, the judge reviews it, and they extend the guardianship for another year. Now, the ward is entitled to notice in their native language or preferred mode of communication of any court proceeding to continue, modify, or terminate a guardianship, and the opportunity to appear before the court to express the ward's preferences or concerns. So now when a guardian goes in and they're renewing a guardianship, and if the ward doesn't want to be under a guardian anymore, they can request to appear in court to contest the renewal. If they have a complaint about the way they're being treated by the guardian, if the guardian is not allowing them to go into the community or do whatever, they can bring it to the court's attention. Number 12, they have the right to a court investigator or guardian ad litem or court attorney ad litem to investigate a complaint received by the court from the ward or any other person. They also have the right to participate in social, religious, recreational activities, training, employment, education, habilitation, and rehabilitation of the ward's choices in the most integrated setting. So this allows people, if they're under a guardianship, it does not mean that they're to be segregated, locked in their home, locked in a nursing home, a warehouse somewhere, that they have the right to be full participants in the community. Number 14, they have a right to self-determination in maintenance, disposition, and management of real estate and personal property after essential living expenses and health needs are met, including the right to receive notice and object about the substantial maintenance, disposition, management of clothing, furniture, vehicles, and other personal effects. I can give you an example of something that we litigated many years ago. We had a client that was placed in a family put our client in a nursing home, and she had been living in her own home. She was an artist. She had all these paintings, and her family went and sold her home. They got rid of all of her possessions. She had nothing. And what this right does is says that they have a right, our client or all people have a right to get notice and object to the sale of their home, object to the disposal of their personal effects, vehicles, whatever. So it at least allows people under guardianship for a day in court so their opinions and their views can be heard. Person under guardianship has a right to personal privacy and confidentiality in personal matters, subject to both state and federal law. This is another area, right number 16, that is highly contentious, and it's the right to unimpeded, private, and uncensored communication and visitation with persons of the ward's choice. A lot of times, and we get involved in cases where a person, a family member who's maybe at odds with the guardian, a high school friend who wants to visit a person under a guardianship who may have had a head injury and is in a nursing home, wants to go visit, and the guardian says no. And now the Bill of Rights state that a person has a right to those types of contacts, except a guardian, if the guardian determines it would cause substantial harm, the guardian may limit, supervise, or restrict communication or visitation, but only to the extent necessary to protect the ward from harm. And then the ward can request a hearing to remove any of those restrictions imposed by the guardian. So a guardian could say you can't visit with someone, you can't talk to someone, you can't, whatever, but it's only if they believe that it's going to be substantially harmful to the person to have that type of contact or communication. But then the ward has the right to go to court, and the court gets to review those decisions. 17. The ward has a right to petition the court and retain counsel of the ward's choice who is certified. And the term who is certified means that they've gone through the training that's been approved or that's required for people in probate matters, and that the person can retain an attorney to represent the ward's interest in the determination or modification of a guardianship, the appointment of a different guardian, or other appropriate relief under the Bill of Rights, including transition to supported decision-making. So, when some of the earlier drafts of the Bill of Rights had a cause of action, and it said that a ward could file a lawsuit in the probate court in order to enforce their rights. And again, there was concerns about, generating litigation. And this allows, at least, to allow a person who's under a guardianship, and if they want to change their guardianship, or if they think that one of their rights, for example, their visitation rights or whatever, are being violated by the guardian, in addition to complaining to the probate court, they could also retain an attorney to represent them in order to enforce their rights. And so this is a very important aspect. Number 18, people under guardianship have a right to vote, marry, operate a motor vehicle, unless restricted by the court. Another thing that's been added, which is very important to the Bill of Rights, is that it imposes a duty on guardians that the guardian or the guardian's designee has to visit the once every 3 months, but more often if necessary, unless the court orders otherwise. A lot of people that are under guardianship have told us that they never see their guardian. Their guardian never responds when they call. Sometimes when people are placed in these facilities, the guardians never see it. They don't see maybe if they're being subjected to neglect. So it's important, and the Bill of Rights now requires the guardians or their designee to visit every 3 months. And a lot of times, and the way for a designee was put in there is a lot of the people that have guardianships are elderly. They may be, like a spouse may have guardianship over their husband or wife, and the person may be placed in a nursing home, hundreds of miles away. They can't travel, so they could designate a family member or someone else to visit on their behalf. Right number 20 is the right to be informed of and allowed to meet and talk with Disability Rights Texas if they have any complaints. Also, the right to be informed of the name, address, phone number, and purpose of any independent living center, any area agency on the agency, any aging and disability resource center, or any local mental health or intellectual and developmental disability service, and to communicate and meet with representatives of those agencies. Just because you're under a guardianship doesn't mean that you're cut off from access to advocates and people that can assist you. 22, you have a right to be informed of the Judicial Branch Certification Commission and a procedure to file a complaint against a certified guardian. This applies when you have professional guardians, so people are aware of how they can file a complaint. They also have the right to contact the FPS to report abuse and neglect. And finally, they have the right for the guardian to explain the Bill of Rights to the ward in their native language or preferred mode of communication. Out loud, people. And their preferred mode of communication on appointment, and each year on appointment of the guardian, as well as at the annual review. So each year the person should be advised of the Bill of Rights. Enforcing the Bill of Rights, again, a person under guardianship can file a complaint with the probate court regarding any violation of their rights, and a person could petition the court and retain counsel to represent them for their interests for any other appropriate relief under the Bill of Rights. The final section deals with court-initiated guardianships. I know we're getting close to an hour and a half, and I'll be quick on this. But HB 1438 provides additional due process protections for people who are subject to court-initiated guardianship proceedings. And essentially, the HB 1438 allows a person who's alleged to be incapacitated to have the right to stop a court-initiated guardianship before an application for guardianship is filed. And the procedure for court-initiated guardianship is, first of all, if a court has probable cause to believe that a person is located in a county, is incapacitated, and they don't have a guardian, the court can appoint a guardian ad litem or a court investigator to investigate whether or not the person is incapacitated and needs a guardian. A court-initiated guardianship is normally triggered by an information letter with the court alleging that a person needs a guardian. So someone could write a letter to the judge. They can say, I think this person is incapacitated, and then the court would appoint either a guardian ad litem or a court investigator to go out and investigate whether or not they need a guardianship. If the guardian ad litem or the court investigator thinks they need a guardianship, then the court starts a process where an application for guardianship is filed. What this law allows is that when the court appoints a guardian ad litem or a court investigator to investigate whether or not a person needs a guardianship, the order has to state that the person has the right to petition the court to have the appointment of the guardian ad litem or the investigator, their appointment be set aside. And then the guardian ad litem or court investigator has a duty to meet with the person believed to be incapacitated, and that they shall provide them a copy of the information letter that served as a basis for the court-initiated guardianship and the order, and to discuss the contents of the letter and the order with the person who's believed to be incapacitated. And then from the date of that initial meeting and the filing of the application of the guardianship by the guardian ad litem, or if the court appoints an attorney ad litem, the person believed to be incapacitated can petition the court to have the guardianship, the appointment of the guardian ad litem or court investigator set aside. So the purpose behind this is they initiate an investigation. A person says, I don't need a guardianship. And so before the whole guardianship process is initiated, the person can come in and ask the court to stop the process. They can present evidence from their doctor showing they don't need a guardianship or what have you. So this is an important procedural safeguard for people who are faced with the possibility of getting a court-initiated guardianship. This is the end. I think some people said that they had trouble hearing me. I apologize. If there's a large number of people who feel as though they were unable to hear this, I'd be happy to redo this at another date. If anyone has any questions, please, you can unmute your phone and you can ask a question.
Richard, this is oh, sorry. I was just going to ask if we expect any kind of handouts or whatever that are in the process of being created that will be on our website about this.
It's coming. I mean, I think we're just at the beginning phase of educating people on this, and I think we're going to have to do a lot of developing of handouts and materials and on this. One area that we're planning on doing with the UT Law School is to develop a project on supported decision making. And we're meeting with Lucy Wood, who used to work here, on Monday, to see if we can get the law students to develop a handout for supported decision making, both for people with disabilities as well as supporters. But I anticipate that we will have a lot of materials on this.
Yeah, we're in the very final phases of our transition guide, and I was going to add at least the link to the simplified form from TCDD, and just didn't know if there was anything else besides just linking to our website that I should include.
Yeah, sorry, I'm not aware of anything else that's been developed.
Yeah, maybe just the Bill of Rights would be a good kind of standalone handout that would be quick.
Right, or you can just attach the Bill of Rights.
Yeah.
Dustin, this is Edie.
You can have a link to the Bill of Rights.
Dustin, this is Edie, and I'm on the phone, and I'm definitely thinking about what we need to change on the guide.
We can follow up afterwards.
So, yeah, I'll follow up with you and Richard, and we'll figure out something to put in there.
Great.
Richard, thank you.
And the other thing, Dustin, is we're going to be, hopefully, the DD Council is going to have an RFP for doing training on the guardianship reforms and supported decision making. We're going to apply for it, but even if we don't get it, we're going to train. And we're going to, and what I'd like to do is not only train lawyers and judges and whatever, but I'd like to coordinate training with this whole supported decision making project, where we can talk to family member and people with disabilities, come in and talk about guardianship, supported decision making, and then run clinics where we can help people enter supported decision making agreements. But if you know of any groups around the state with parents or people with disabilities who might be interested, we need to start setting up training.
So many of the guardianships are initiated by legal aid programs and the volunteer lawyer associations and the law school clinics. In Houston, I know legal aid, all 3 law schools' clinical programs and the volunteer lawyers program all do a ton of guardianships. And so I think educating our friends in the legal service industry might be a good place to start.
And I think that's an excellent point. And part of the GRSDM, the work group that we were on, Julie Belovich with Trala was on the group, and she was the one lawyer on the group that was a practicing probate attorney who did a lot of guardianships, and she brought to our attention how, as a lawyer, family members, and it's because the schools are telling families they need to get guardianships over their sons and daughters, and the families come in and they say, I need a full guardianship. And then the lawyers at Legal Aid would petition to get a full guardianship, and Julie told me she was always shocked that the attorney ad litems that are appointed did nothing. They would just agree, and they would never contest it. They would never question it. So I think that you're absolutely right, that we need to hit all these programs, and it's something, once we start doing training, I'll contact you and we'll start setting it up. The other thing that we're going to do regarding training, and Steve Aliman is already, he was able to get some language regarding supported decision-making into the DEA-approved transition guide. And we had a meeting about a month ago and to update the guide, and we started talking about the guardianship reforms, and all the people that were released on the transition work group with TEA were very excited about the guardianship reforms, and Steve is going to set up something where we can do it with the education service centers. You know how they do those massive statewide videos? So we're gonna do that to educate educators, and also try to get invited to TCASE to educate the school lawyers. They don't have a clue about this, and a lot of times the school people rely on bad advice from their lawyers about guardianship that end up in we're getting overly restrictive guardianships.
We can get that TCASE invitation. I'm speaking for Region 4, which is the state lead on transition, on this topic next month, and I think the person who scheduled that can probably get us invited to TCASE. Good.
No, we need to do that. Thank you.
Richard, this is Sean. You were talking about the guardianship programs at law schools. If Dustin, I'll tell you this, if you want to start anywhere with that as far as educating them, South Texas College of Law, my understanding that's what our former attorney, that's where Eric is, and I think he's running that one. And he was asking me when he went to leave to go do it about supported decision making. So I know he's really open to trying to get that integrated into their program.
Perfect. You know, with him, and that's something where what we'll do, and I'll be meeting with Lucy Monday, is that we'll have something we'll have Lucy contact the law school. So there's 2 ways of doing it. There's going to be one effort to do supported decision making, but the other effort is educating all these volunteer lawyers and clinics that do guardianships, and to educate them about the alternatives and about supported decision making and the Bill of Rights. So it's almost like a 2-pronged approach, because we can do this project with South Texas to set up a clinic with pro bono lawyers, and it's something we'll try to get Cicely involved in, to recruit pro bono lawyers to work with pro bono law students to help people. But the other side of it is we have to generate enough, we get the word out into the disability community and the schools about supported decision making and getting referrals to people that would like to enter these types of agreements.
Richard.
Are there any other questions? I'm sorry.
Yes. If you're arguing supported decision-making as an alternative to guardianship in a restoration case, is there anything new in the reforms that talk about making a finding of the ability of the ward to enter into a supported decision-making agreement? It sounds like, that sort of makes sense.
Yeah, that would be, the court would make a finding. Yes, Yes, it would say that with supports and services, and I would argue a supported decision-making agreement is a support. So one of the alternatives is you go in, you're representing someone in a guardianship or a restoration, you can have the person who's a supporter come and testify in your client about how they want to do a supported decision-making agreement. You know, when I was preparing this PowerPoint and getting ready for this presentation, I thought of another area. You know, in my legal career, I did one guardianship, and we needed a guardian because we were filing a lawsuit on behalf of someone who was incapacitated. And our client's family member was indigent and lived in a rural area. And so we did a guardianship of the estate. And so I don't know if anyone's on the call as clerked for us when we were doing that case, but every year we would have to do an annual accounting where you had to account for every penny in the estate. And I mean, literally the probate, when we do an annual accounting, I never would do them because it was too complicated. I'd give it to a law student, and they would almost spend half the summer trying to get all the records and settling the account to make sure that all the money was accounted for. And I can see us approaching our guardians who are sick of doing these annual accountings. They have to pay for lawyers. They got to go through the hassle of doing the annual accounting. And by entering into a supported decision-making agreement, we could go back into court, end the guardianship, and there's no reason why the person who's under the guardianship, if they want their guardian to be involved in their life, they can enter into a supported decision-making agreement. So it doesn't even have to be another person. And that may be there may be a big need for that, especially a lot of these families that were told by school districts, oh, you need to become guardian if you want to attend an ARD meeting or make decisions after your son or daughter turns 18. And their kids are working, living, doing whatever. They may be ready to say, hey, I don't need to be their guardian. Let's do a supported decision-making agreement if the adult child is in favor of it. So I see a lot of opportunity here.
I have another question. You had a slide that talked about the findings that the court has to make, and I think the slide said something about you have to consider supports and services, and I think it said something about making a finding that they would not be feasible. Is there a definition of feasible in the provisions?
No. I mean, these are all issues that can be litigated. No, it isn't defined. So you'd look at the plain language of feasible, and then it would require us to present evidence. And it's something where, I look at it as down the road, great litigation for us. I really think it's a priority within the agency in the next couple of years. If people have supported decision-making agreements, and then someone initiates a guardianship, I would love for us to defend them in the guardianship case and go in and, prevent the guardianship by saying they had a supported decision-making agreement, or they had supports and services. I mean, there's a lot of opportunities here for us to really litigate cases and to establish some good case law. Because in the Toner case, and Kayla and Lisa did a phenomenal job in briefing in that case. And there is very little case law. I would think there's a handful, like maybe 6 or 8 cases in the country on supports and services. And so it's really important for us to develop a body of case law on supports and services. And I'm hoping that the Texas Supreme Court, takes up Toner on appeal, and we have an opportunity for the court to rule in our favor. Any other questions? Well, I appreciate everyone taking the time to go through the training. Shoot KP an email with your bar number, and she will apply for CLE credit for you. We also have recorded this presentation, so if someone who wasn't able to hear it, could go and listen to it and get CLE credit or CEU credit. Again, thank you, and I appreciate it. Bye.
Thank you.
Thank you.